Good evening. I want to welcome all of you to this evening's event. Does DC's planning and zoning need an overhaul? My name is Shelley Repp, and I am chair of the Committee 100 on the Federal City. 2023 is our centennial year. Over the course of the year, we have marked this milestone by holding a series of what we have called conversations, focusing on some of our city's challenges. Planning and zoning have been at the heart of what the Committee of 100 has done ever since its founding. So it is fitting that as we conclude our series of centennial conversations, we take a critical look at these processes from the perspectives of residents, activists, and the land use attorney, from the perspective of residents, activists, and a land use attorney. As you will see, we have really good attendance. As you will see, we have really good attendance for this evening's conversation. That speaks to the importance of the issues that will be addressed this evening. Everyone who registered for this evening's conversation should have received by email a white paper on planning and zoning in the District of Columbia that we hope set the stage for this evening's conversation. I don't know if they're still there, but there were a few extra copies on the outside in the narthex. But regardless, all of you should have gotten a copy in the email, which you can read later. Our distinguished panelists, Nancy MacWood, Laura Richards, Max Tondro, and Parisa Norouzi, have an extraordinary knowledge about land use, law, and regulations. You will find their more detailed profiles in the program that should be on your chair. The panel does not purport to represent all points of view, but we will offer constructive suggestions about how planning and zoning might better serve the city and its residents in the future. Nancy MacWood will serve as moderator and panelist. Nancy, a lawyer by training, served 22 years as an ANC commissioner in Ward 3 and also as task force member on the comprehensive plan and on the rewrite of the zoning regulations. She has served in the past as chair of the Committee of 100 and currently is vice chair. Recently, she was the primary author of the Committee of 100's analysis of the Office of Planning's amendments to the comprehensive plan's citywide elements. We will save time at the end for people to make suggestions. Please keep your comments brief and germane to the topic of this evening's event. After the program, please join us for refreshments and conversation in the narthex. Committee of 100 members are identified by badges like this one here, and you are invited to talk with any of us and learn more about our organization. We welcome new members. With that, please welcome Nancy MacWood.
Thank you, Shelley. Good evening, everyone. This final panel discussion in the series celebrating the Committee 100 Centennial was chosen because it covers institutions and policies that affect all of us at one time or another. The Office of Planning and the Zoning Commission actions can be transformative and too often beyond our control. The public should feel empowered and engaged in planning and zoning processes, and we think there are ways to make the institutions and processes more democratic. On our panel today are experts, both in terms of their experience and their consistent efforts to strengthen public influence. To ground our discussion, I want to share a little background. I'm going to use abbreviations occasionally. OP will be the Office of Planning, ZC for the Zoning Commission, and IZ for inclusionary zoning. Citizens often complain that their views aren't valued by OP and the Zoning Commission, and that as hard as they try, their recommendations or testimony don't influence OP's recommendations or the Zoning Commission's decisions. There seems to be an unarticulated agenda that the public can't crack. At OP, keeping the public at arm's length is exemplified by their sticky note consultations. How many of us have attended public meetings where we are confronted with poster board options and our input is limited to writing a sentence on a sticky note? There's so many reasons to object to this format, but for me, the message is that the Office of Planning doesn't want to hear from me if I have more than 10 words to say. How many technical amendments to the zoning regulations has OP proposed? Hundreds? Several hundred? How can there be that many grammatical mistakes that shouldn't have citizen input? Why is OP proposing changes to the zoning regulations that limit notices and public participation in some proceedings? If the Zoning Commission is overburdened by its agenda, maybe OP should refrain from offering so many zoning changes. But curtailing citizen participation seems the last solution it should suggest. The distrust of OP is increasing as it pursues these unfriendly actions. Recently, it flipped the script on the Chevy Chase community by interpreting a new small area plan to allow denser zoning at the library and rec center site than the community thought it had supported. The Zoning Commission, importantly, is not part of the mayor's economic development apparatus, as is OP. It is supposed to be independent, but our collective experience is that the Zoning Commission accepts every text amendment, technical amendment, and map amendment that OP endorses. When citizens disagree with a proposal or a development project before the Zoning Commission and can testify, they very often report feeling dismissed or disrespected. As an ANC commissioner, residents would tell me, ranging from lawyers to retirees, that they would never again testify before the Zoning Commission, that it was rigged in favor of applicants, and that the Office of Planning was getting more deference than great weight requires. It's important for us to understand how we got to this unsatisfactory place. The impact of the Financial Control Board established by Congress in 1995 was profound. It literally had control over mayoral appointments, budgets, and decisions of the council. It wasn't officially disbanded until 2001 after restoring some independent functions after the election of Anthony Williams. Even though the economy was stabilizing, the mindset was we had to beg for development and we shouldn't do anything to frustrate development, which would be key to a sound financial future. Our timidity was exemplified in the long and tedious Zoning Commission deliberations over inclusionary zoning. The ZC was hyper-focused on whether IZ would incite developers to leave DC, which is what developers told them would happen. That is one reason the downtown is exempt from IZ. Passed in 2006, the administration took 3 years to write implementing regulations. The council has also played a role in our current situation by handing over more of its authority over land use and development to the Zoning Commission and thus to the Office of Planning. The council has sole responsibility for approving the comprehensive plan, which is the only document the Zoning Commission must abide by. The Zoning Commission cannot approve regulations or projects that are inconsistent with the council-approved comp plan policies. In a demonstration of its hubris, OP urged the council during the recent comp plan amendment cycle to rewrite the plan with more vagueness and less guidance. While the council wisely refrained in many instances and even added explicit racial equity requirements on OP and the Zoning Commission, it also inexplicably removed most guidance on appropriate development densities. This was done in the face of heightened public unhappiness with OP and the Zoning Commission. The comp plan victory for the Office of Planning in its effort to increase its sway on the Zoning Commission followed its successful effort to convince the Zoning Commission to rewrite the zoning regulations in 2016. Many of these changes were inconsistent with the comp plan, but OP argued that the comp plan would change soon to support its zoning changes, and indeed it did. Among the changes the Office of Planning facilitated in furtherance of the mayor's economic development agenda were the elimination of neighborhood overlays, the downgrading of neighborhood context as influencing commercial uses and density, and the introduction of public transportation access as a key determinant of appropriate development. One of the significant signals of OP's agenda to lessen public influence on land use and development was their startling elimination of each planning area's planning and development priorities from the comprehensive plan. These priorities came directly from residents who participated in well-attended ward-specific meetings with the Office of Planning consultants. After citizen protests, OP reinserted most of the priorities in the area elements, but added a disclaimer that they had not been updated and thus might not be relevant. OP also recommended upzoning authority in many of the locations where the 2016 zoning regulation changes, such as the elimination of overlays, laid the groundwork for density changes. OP admitted that its intent in revising many of the comp plan policies was to prevent residents from appealing zoning commission decisions and holding up development projects. That pretense was used to diminish the importance of resident-type concerns and issues related to the comprehensive plan. We see limiting resident participation in zoning cases continuing, with recently approved zoning amendments by the Zoning Commission to curtail some public notice requirements and to authorize the Zoning Commission to remove conditions from planned unit development orders without involvement of the community that may have asked for the conditions in the first place. The final determinant of how we got here is perhaps the most important and is expertly analyzed in Larry Hargrove's white paper distributed before this event. The Office of Planning has assumed the dual role of facilitating the mayor's economic development agenda and advising the Zoning Commission on how it should interpret the comp plan and decide all cases. Almost no regulatory changes get to the Zoning Commission without the Office of Planning authoring them, and no cases are scheduled for hearings until the Office of Planning works with applicants and confirms its support. Many citizens see an inherent conflict of interest since the mayor's legal involvement stops with appointing 3 of its 5 members. The mayor cannot overturn a zoning commission decision, and yet the mayor's team has a unilateral role in influencing every zoning decision. An obvious question is why the independent zoning commission permits the Office of Planning to sit on its dais and have so much more influence than any other person or entity. We're going to look at some of these issues this evening and how we might right the ship so that planning and zoning are more democratic. To be sure, we all need to be involved. Citizens must better understand the interplay between the mayor, the council, the Office of Planning, and the Zoning Commission, and demand the roles be consistent with how the DC government is supposed to work. The council should fulfill its role in determining predictable and clear land use and development policies that can be implemented. The council included this type of guidance in the comp plan on racial equity, so it can be done. The mayor should acknowledge her limited authority regarding the Zoning Commission and pull the Office of Planning from serving as the Zoning Commission staff. Former Attorney General Racine pulled staff attorneys from serving as the legal counsel for the Zoning Commission so it could represent the public interest on zoning matters. So realignment can happen. One of our panelists, Mr. Tondro, could speak to that. He was previously advising the Zoning Commission and now no longer does. And he's representing the public interest for the Attorney General's office. The Zoning Commission should hire an independent expert staff to maintain its intended independence, and it should move the Office of Planning staff from the dais to the witness table. What does our panel think? Let's begin a robust conversation and think about what changes can be made to turn this around. Let me briefly introduce our dream team, and believe me, this really is a dream team. Parisa Norouzi is the co-founder and executive director of Empower DC, where she has led grassroots organizing efforts on a range of issues, including childcare, housing, land use, environmental justice, and racial equity since 2003. Her work centers on building community power to advance equitable development by ensuring impacted community members are the visionaries, drivers, and beneficiaries of land use decisions. She is particularly proud of her 20-plus years of work with Ivy City residents to win public use of the historic Alexander Carmel School as a community center and park, long desired by residents. Laura Richards has been active on planning and zoning issues for nearly 40 years, advocating for fair treatment of all communities, a greater public voice in decision-making, and respect for valued elements of the city's built environment. She is a longtime member and former chair of the Committee 100 and a former chair and member of the DC Board of Zoning Adjustment. She has worked on every iteration of the DC Comprehensive Plan since the 1980s, serving on the Office of Planning's task force, convened for the 2006 plan, and as one of Mayor Gray's representatives on the Zoning Review Task Force that culminated in the 2016 zoning code. She is a vigorous defender of the 1910 Height Act. She currently serves on the board of the Marshall Heights Community Development Organization. She is a retired federal attorney and one-time newspaper reporter, and she currently lives in Penn Branch in Ward 7, having formerly lived in the Anacostia Historic District. Maximilian Tondro is the chief of the Equitable Land Use Section at the Office of the Attorney General for the District of Columbia. He has served in various roles in the district's land use processes, including advising the zoning administrator at the former Department of Consumer and Regulatory Affairs, and as a Capital City Fellow at the Office of the Deputy Mayor for Planning and Economic Development and the Office of Planning. Mr. Tondro also worked briefly in the Office of the General Counsel for the Prince George's Planning Board of the Maryland National Capital Parks and Planning Commission. He served as a member of the Planning and Zoning Commission of his hometown, Hartford, Connecticut, which is the first planning commission in the United States, established in 1907. He wasn't working with them then. Mr. Tondro has a background in architectural and urban history, which he taught in several American colleges, having earned his PhD from the University of Cambridge in Great Britain. So, as you can see, we've got an esteemed panel, and we're going to begin immediately to ask some questions and get into our discussion. So, Parisa, I'm going to pick on you first. So what do you think? I mean, I've said I think the Office of Planning has an outsized role in zoning processes. What do you think?
Say it with me, right? Do we all agree? We all agree the Office of Planning has an outsized role in the zoning decisions, is that right? I think the thing that was really shocking to me to realize is that the development review section of zoning is divorced from the community planning section. So it's not the community planners that are helping to advise the zoning commission on a particular development and how it might, factor in with the different equity issues or housing needs, et cetera. It is the more bureaucratic section that is development review. And now that we incorporate also the comp plan consistency to include racial equity analysis, I really fear that the folks that are doing the racial equity analysis in the comp plan consistency in development review are not qualified to do so. Can we agree on that as well? And, you know, I will say, by no means do I consider myself an expert on these issues, but I have learned a lot through the process of working with residents in Berry Farm, navigating the process, dealing with the Crummell School. And so, you know, one anecdote on Berry Farm was that when that case was appealed, when the PUD, the approval of the PUD was appealed for Berry Farm, the court did indicate in its ruling that the Office of Planning representative indicated that they had no real knowledge of the Berry Farm community during the proceedings of the Zoning Commission, that they could not even answer the most basic demographic questions about the community. And so again, I think that shows that this section of OP is really there to rubber stamp and less there to really be connected to the community interests.
Even though I directed the question to one panelist, I'm very interested in what the other panelists have to think. So everyone should have their own microphones there. So Laura and Max, what do you think about OP?
Well, I couldn't do more than say amen, Nancy. I had made a few notes, and one of them says Office of Planning, Hydra on the Potomac. And because I did, you know, it has all these multiple roles, and I now, you know, think listening to you speak, it's everywhere, everything all at once for the Office of Planning. It's a real problem, and OP has become, I guess, much more overt and glorifying in its kind of control role. And disturbingly, the Zoning Commission has been very, I want to say supine. I don't want to say it's supine, but I guess it's been supine and acquiescing to it. The Zoning Commission, you know, could take a stronger role. It could insist on some, you know, some independence. It could probe OP more searchingly. It could take advantage of the AG's role. It could lean more heavily on its own in-house lawyers for assistance in moving through some of these things. But it continues to lean on OP. It's one of the greatest cases of regulatory capture that, you know, you would imagine, and it's all happening within the government, you know, and so I think that trying to tease apart and get some legislative action on the conflicting roles at OP is probably the most promising place to begin. Now, with regard to racial equity, the Zoning Commission had a roundtable on racial equity when they were going to develop their tool last spring, and everyone came and testified and said, we want it enshrined in the regulations. And by the time the Zoning Commission put out its policies, it's not a regulation, it's just a website policy. Zoning Commission was asked about it, and they said, oh no, you know, despite what we said about it'll go in the regulations, we thought, no, not a good idea after all. We want to stay flexible and so on and so forth. So that was a very recent case of kind of yielding to the Office of Planning's advice to kind of keep it loose, don't put anything hard and fast where you can have some serious accountability.
Why don't we, since both of you, both Parisa and Laura brought up racial equity, let's move right away to a question about racial equity. The council has approved more explicit language in the comp plan on racial equity during markup. They did that. In this case, council made it clear that its guidance was directed to the Zoning Commission and its processes. The intention is to have a racial equity analysis applied to every zoning case and to have that information influence decisions. This was done because the documentation of discrimination and displacement was well publicized and shocking to most residents of the district who had no idea, a situation the council could not ignore. The Zoning Commission complied with drafts and public roundtables, as Laura mentioned, and published final suggestions to applicants that it says it expects them to follow. There's potentially a lot to talk about here, but I want to discuss if you think the Zoning Commission's racial equity tool is as rigorous and as analytical as the diversity and breadth of racial equity issues deserve. The tool relies on applicants to identify the community where its proposed zoning action will be applied, conduct outreach with that community, and determine from these interactions what the potential negative or positive impacts would result from approval. The applicants are encouraged to use the OP database as a resource for determining some historical and current indicators of racial inequity. My thinking on this is that we have ample information already about how redevelopments have reshaped DC's racial and economic geography. Couldn't we start with some facts about what systemic inequities exist in DC, where they are present, and what improvement looks like? Why isn't OP doing an in-depth policy analysis like the Council on Racial Equity's legislative analyses, which interestingly, they turn around in 10 days? What we need to hear from OP is what the background, the current racial, educational, environmental, transportation, employment, income factors that development may affect. Why isn't some version of this analysis presented at set down before the Zoning Commission even decides whether they want to go forward with a hearing? And why is the Zoning Commission targeting an unidentified, an undefined community identified by the applicant? Doesn't racial equity issues extend beyond one community and one project? Can we make progress if zoning decisions are this narrowly focused on systemic racial inequity in one community or neighborhood? That's a lot of questions, but who should be doing this analysis? Let's start there. Parisa, what do you think?
I definitely think the analysis should be done by an independent entity that has an expertise in this. But, you know, as we dug really deep into this tool and the data that it requires, what we recognize is that this is not something that can be relegated just to the Zoning Commission or even the Office of Planning. The data needs to be collected in a consistent and transparent way throughout the government agencies, you know, DHCD, the Housing Authority, Department of Human Services, et cetera. And the reality is that we are still at a stage on racial equity where it's really just talk. We have not built the capacity within all of the district agencies to imbue the racial equity ethic throughout the work of the agency. Right now we have, as you mentioned, the DC Council Office of Racial Equity that is doing good RIAs, racial equity impact assessments. However, they're very limited in terms of their authority, right? So it's only if the council members really choose to look at them and choose to take direction from them. Most of the public is still unaware of them. The Mayor's Office of Racial Equity is responsible for building the racial equity capacity within the government agencies, including planning and zoning. And they focused more on giving staff training around racial equity, and they've started supposedly this process around racial equity goal setting, but it's still very general, and we're not getting to the point where we're even defining what does it look like to move the needle on racial equity. All of that said, our analysis is that the biggest game changer is in the community engagement. And if we can significantly shift the standards of meaningful community engagement, we change the conversation. And I've seen this time and time again, that once impacted people are in the room, the conversation changes. And so if we can really, and the reality is until we as a society are willing to pass laws that say if it's racially inequitable, you cannot do it, which we are not at. We are at a point of saying, let's study if it's racially inequitable. Maybe there's, a conversation starter there, but we're still not at the place of saying, oh, it's going to harm black people, so we shouldn't do it as it's disallowed, it's illegal. We haven't ever said that. So the biggest game changer is to do such substantial outreach and engagement that actually is technical assistance, right? That's actually supporting residents with having knowledge about the zoning process, with being able to capably navigate the zoning process, and at the same time reform the zoning process so that it is more inclusive and equitable. That is the big game changer. And so those are the things that we're thinking about. And just to say one more sentence about it, it is completely inequitable that we rely on ANCs as the conduit of all manner of, notice to communities. As we know, there's no standard of ANC activity. There's no minimum standard that they have to meet once they receive notice. Some ANCs are very active. You spent many years being active on these issues. Other ANCs have no idea what they're looking at when they see this notice from the Zoning Commission. And so if we're going to set things up in this way, then we do have to define at least some minimum standard of requirement for this engagement.
Max, I want to bring you into the conversation. I didn't mean to pass you by on whether you have views about the role of OP in the zoning process. So if you're dying to say something about that, please do. But also, I'm really interested in you've had a very interesting experience, different than any of the rest of us here, in that you were advising the Zoning Commission as their lawyer for many years, and then the script got flipped and you became a public advocate on behalf of the Attorney General, with part of your role being outreach and trying to get more people involved. Can you speak a little bit to that and how and whether you have any personal experience about the racial equity situation?
Sure, I'll try to see if I can respond to all of those, if I can remember them all. Yes, I was very lucky to have had the opportunity, the variety of opportunities that I had within DC government to work in various different areas. It's been very helpful for me, at least, to understand how the various different departments and agencies interact. I did advise the board and the Zoning Commission that in that capacity, I provided confidential legal advice. And so as a result, once our roles switched, we made absolutely sure that anything that we had advised or dealt with at all was something that just out of an abundance of caution, ethically, we were not involved. Just to be clear with that first off. So going forward, but there was an agreement between the then Attorney General, the council chairman, and the mayor that we're all required to join together to make it work. In terms of your question earlier about how changes can happen within agencies or assigned roles can change. So there was the small p political willpower to make that happen. We can also think maybe it's a slightly different scale perhaps, but we've all seen how DCRA changed to DOB and DCLP, and that has its, that took a lot longer. And so, any kind of change of roles or assignment would take that, I think, small p political willpower to agree, an agreement of the minds. It has been, it's a great honor for myself to be able to try to advocate in the public interest. I think I hope that this is something where we can help the conversation, move it forward. It is. And again, I should say, I'm speaking personally in this capacity right now, and I don't want to, I work for the Attorney General, but I'm not here representing him tonight, just to be clear about that. But the point is to make sure, from my standpoint, I think I want to make sure that we are improving the situation. I'm not here. I don't believe that our role should be just to stop or to cause problems. To raise questions that need to be considered, to raise questions that should be addressed is one thing, but to be constructive is certainly, I think, a key part of the way I view our role. So let me see the other questions you asked, Nancy, if I can remember. In terms of the racial, I think one sort of thought I had, just echoing, I think Laura and Parisa as well, is, in terms of the role of OP, ultimately it's the zoning commission and the board who are the deciders. They are the ones who the Home Rule Act gives the authority to, and they are the ones who are accountable. So they obviously rely on the Office of Planning, because the Office of Planning are experts. The Office of Planning has a much bigger staff. But ultimately it is up to the Zoning Commission or the BZA to respond to what OP provides. It is sort of interesting. There have been times when the BZA, even though they have a representative of the Zoning Commission of the BZA at times has chosen to not necessarily ignore, but to not necessarily listen to the Office of Planning or to give them the same kind of credence that sometimes the Zoning Commission does more. So I think it's possible. I think sometimes it's a matter of the commission or the board having. I think those times when the board does sort of reject all or part of what the Office of Planning has suggested is because there have been testimony or there's evidence provided by others at the public hearing. And so I think that goes to sort of this broader role of public participation to make sure that all voices are heard. I think is really, really crucial. And I think that raises a question, I think, for like considering text amendments, when it is that the role of public commentary should be. And this goes back to this issue of the Zoning Commission sort of, as you had said, the Office of Planning, that generally, unless the Office of Planning supports a proposed text amendment that's brought by another entity, that the Commission is not going to even consider it. And I think that raises some questions as to whether or not, a vision question as to whether what is the appropriate role or place, arena for public discussion about those. Is it sort of a back of the house discussion in the Office of Planning on the basis that they have the technical expertise, or are there certain circumstances when those conversations should be had, disagreements, but that can be raised and then can be discussed at a public hearing, as I think often happens with the BZA. Obviously, BZA are very different. They're very specific cases. They're different from a text amendment. But I just would throw that one out there. And then, let me stop there.
I just have a quick follow-up. So now we have an equitable land use division in the Office of Attorney General. Obviously, there is a lot of expertise there. There is a lot of knowledge there. Do you on a regular basis hear from the Office of Planning about what you think? Or do you hear from the Zoning Commission saying, come on down, we want to hear what you have to think about this? How are you being integrated into the process, or are you sitting at the witness table like the rest of us trying to be heard?
I think I would just say change is difficult. I'm sorry, I apologize. Yes, thank you for yes, please let me know if I'm not speaking loudly enough. I think change is difficult, and I think there has been a way in which things have been done for many, many years, and our role is new. I'm not sure. I think we hope that we are adding value to the process. I think some would feel that. I think there have been others in the process who would be just as happy if we were not there. But it's an ongoing process. And again, I think the goal is to try to bring value and add value.
Yeah. Well, let's move on to another one of the issues that Larry mentioned in his paper, and I briefly commented on. The Home Rule Act, which established our governance structure, states the mayor is a central planning agency for the district. She has a responsibility for coordinating municipal planning activities. She appoints 3 members of the Zoning Commission and 3 of 5 members to the Board of Zoning Adjustment, the BZA. And that's where her authority stops on zoning matters. She has no authority to review either ZC or BZA decisions. So have these bodies just abandoned their intended independence from the mayor by relying on the Office of Planning and allowing mayoral influence where it wasn't intended? Can these bodies hire independent staff? There was a law that was passed in 1990, the Office of Zoning Independence Act, whose purpose is to assure the BZA and the Zoning Commission make uncompromised decisions with the assistance of professional, technical, and administrative staff. So, Laura, is there really a problem with having an independent staff, or is this just a matter, as Max mentioned, of will?
Oh, we clearly need some independent staff. And I remember when that law was passed and great hopes rose from it. But as long as the Zoning Commission remains wholly reliant on OP, then we will not have true zoning independence. Now, we certainly took a step towards zoning independence on the legal front with the in-house legal team. We need an in-house planning staff. It's not going to work otherwise. And I know the Home Rule Act says that the Office of Planning, will provide the technical assistance or the professional assistance. And I don't know if that really requires a charter amendment or not, or if there's some way to interpret around that requirement. One might read that Home Rule Act provision is simply saying that there shall be, professional planning advice given to the Zoning Commission, and the city might have some kind of, leeway to determine how that will be done. Or you could say, okay, here's the Office of Planning, but it's going to have a part of itself that's going to be wholly separate and work for the Zoning Commission, truly. So I don't think that's an insurmountable obstacle. Office again, it is a matter of will. Now, the other problem with those two bodies, of course, are the federal ex officio representatives who decide not only matters within the federal interest, but also they make decisions about our pure DC issues. And I think Larry's paper says they're like the old commissioners. They tell you how big your backyard could be. As we know, Eleanor Norton has introduced a bill to kind of like make all of the members of both bodies DC residents and appointees. And I'm going to stop. Well, and then they can figure out how to guard the federal interest. But just in terms of the professional staff, that can be solved.
Parisa, do you have anything you want to add to this? I mean, do you think that either if, as Laura mentioned, that I knew this would happen at some point tonight. Do you think that federal members of the Zoning Commission, if they hadn't been on, and you had 5 members from DC on the board, or if the Office of Planning wasn't as influential during Berry Farms case, Do you think it would have mattered?
I do think that representation matters, and the fact that we have nobody on the zoning commission who lives east of the river, we have currently no women of color in recent history on the zoning commission. I do think that's a huge problem, and I would love to see people who have community development expertise, true affordable housing expertise. I remember when we went before the board with Berry Farm, and there was a woman on the commission. Was it Marcy Cohen? Was her name? Yeah, and she was not supportive. So it's not that just by virtue of being a woman somehow we're going to get more, But I think that having all men and mostly white men deciding the development of the city is problematic. I would love to see people who have more of a connection to different groups that have been harmed by the development patterns in the city. And I personally think that we don't need the federal representatives. I had a conversation with Max about that one time, and I think, if not to quote you, Max, but I think you were thinking maybe there's some benefit to having some people who maybe are not quite so beholden to the mayor, which I can't remember is that exactly what your take was, but I remember you didn't think that was the worst thing in the world that those folks were on there. Yeah.
Your name's been invoked.
Yes.
I think what I would say is that I think there are many different ways to do things, and I think certainly having there's some others looking at other jurisdictions, it is quite common to have both many more than just 5. So you have you ensure you have a wide range or diversity of views, but also diversity of experiences. Some cities actually specify specific professions. So there'll be a surveyor, or there has to be a lawyer, there has to be an architect, so precisely in order and other cities similarly will limit the number of representatives or commissioners who can come from the same area of the city in order to try to get geographical diversity. I mean, I would say if I was king of the world, which I'm decidedly not, I would think it's also helpful to have age diversity, as well as a very clearly experienced diversity, geographic diversity. But I think just a diversity of viewpoints and experiences is a very important one from if possible. So I would say that I think the new NPS is, however, a woman. I think, right? The representative said that she just started because Peter May just retired. So that is. I'm sorry, the National Park Service. So one of the two federal representatives on the commission. One represents the architect of the Capitol, and the other represents the National Park Service. And so and then the other. So there are 5 total on the commission. 3 are appointed by the mayor with the consent of council. Those are the district representatives, and then there's these 2 ex officio. In other words, no, yes and no. They're right since February of last year, so about 18 months. There's been a seat that's been vacant that the mayor has not nominated anybody. The other 2 are both men. Yes.
Now, the council has a role here because the council has the responsibility of either approving the mayor's nominees or rejecting the mayor's nominees. And I had a council member one time say to me that, if you want to object to a nominee, you need to make that clear to the council before it becomes publicized, before we announce that there is going to be a hearing, because once you have a hearing and it becomes public, council members are not going to, unless there's some sort of scandal, they are not going to reject the mayor's nominee because they feel that that is her prerogative to have her nominees. But what do you all think? Should the council take more of a role if they want to have different type of balance on the zoning commission and the BZA? Should the public expect that the council takes more of a role?
Well, yes, but I think that kind of ties into something you said earlier in your opening remarks about how the city has come to take certain things for granted. Not just that we're going to rubber stamp the mayor's appointees, but that when it comes to development or land use, we're still like stuck on the what do you want to call it, the post control board mentality, or before that, I think there was another reason why we had to keep building and building. But for a good 40, 50 years, we've had one size fits all. It's what are you going to do? You got to talk about land use, comp plan policies. It's all about we're going to take an area, whether it's Pennsylvania Avenue, K Street, McMillan, the Wharf, whatever, and we're going to have gentrified, mixed-use neighborhood. It didn't used to be mixed use; it was all commercial, and we're going to throw in some retail. And we have never had any policies aimed at housing, employing, or providing mobility for poor people, which is about 40% of the city, which is about 90% of all the black people in the city. And we've come to kind of accept that, and we just nibble around the reforms with, we're going to do a little IZ, and we're going to do a little here and that, and we're going to put a Band-Aid. So you said, how do we get out of that mindset and start getting some different kinds of policies at the comp plan level? Yeah. So I'm raising that to you. Oh, to me? Yes. Oh. How did you get that so eloquently on?
How do we get that at the comp plan level? I think it really does come down to public engagement. There are a lot of us who can do the particularly here at the Committee 100. We can do the analysis. We know what's missing. We know how these policies get interpreted and why they're important and how they're going to influence decisions for a long time to come. But the council is going to be much more responsive to hearing from everyone in the audience than they are from hearing from a handful of us at the Committee of 100. I mean, we will try to make life as difficult for them as possible and go to hearings and raise all sorts of issues. But I really think these types of issues, and it's similar to who gets appointed to the BZA and the Zoning Commission. Does anybody ever show up at these hearings that they have? Hardly anybody. They are very summarily usually approved because no one is saying, this may be a very fine person, but we want a woman, or we want a person of color, or we want more representation from people on the other side of the river. We're not going to stand for this any longer. And we're going to fill up the hearing room and make it clear to you that we're not happy with this appointee. And we expect you to reject the appointee and force the mayor to appoint someone else. I really think it's got to be public sentiment, and it can't just be a handful of people. Let me move on to another topic. Our purpose, and this goes with what we were just talking about, one purpose of our topic is to explore what can be done to make planning and zoning more accessible and responsive to community interests. Just what we're talking about. We've already talked about reducing the mayor influence on decision-making by replacing OP staff functions with independent staff. Staying with the Zoning Commission for a minute, it's required to give notice and hold a hearing on every proposed regulation, map, or amendment. Notice must include a summary of all the changes proposed. OP presents hundreds of what it defines as technical amendments that may apply citywide or may apply to one or two zone districts. Often, we don't know. Similarly, Substantive changes to the regulations are often not linked to the area that will be affected. Last year, OP proposed a text amendment regarding WMATA, bus maintenance structures, and no one had any idea until one of the zoning commissioners asked the question where that was going to apply. Would more transparency, more information, and kitchen table language help to engage citizens? The way regulations are written, particularly since 2016, including the sequencing of how regs are applied, seems aimed at a very finite group of lawyers and not an interest in helping the public to understand and participate. So, Max, is there a way out of this pattern? Should there be? Is this something that, oh, well, this is zoning and it's a very legal enterprise, you just got to deal with it, live with it? Or can it be, can it be a process that engages more people and they feel comfortable engaging?
I would think so, although I'm a self-professed zoning nerd, so I grew up going to zoning hearings with my father when I was very, very young. So for me, it's sort of natural, but that I live in a very weird world.
Must have been the only little kid in the area. I can't imagine.
But zoning, I think this has been a topic of national conversation. I was just looking, for those who are interested, there's a project called the National Zoning Atlas, which is an attempt to try to understand and make clear how various different zoning codes are being clear, or that they're somewhat obfuscatory, whether they intentionally so or not. Obviously, one of the problems that happens oftentimes with zoning codes is they get amended little by little by little by little, and it's sort of like a bunch of oysters that are barnacles on the pier. Eventually, you can't even see the format that was there. So periodically, one does need to try to consolidate and sort of revise the zoning regulations to give clarity. The problem is the devil's in the details of trying to get that clarity, and that is fundamental. So I know that the mayor of Boston, for example, I think just this week announced that she was leading a big change, a review of their zoning code, and one of the key things they were trying to do was to make it clearer, make it in plain English. I think the parking regulations, they said, were scattered over, I can't remember right now, 40 or 50 different sections of the code. In other words, one couldn't just go to look up parking and look up height and figure it out on the basis of the one section. It was scattered throughout the code simply because over time, this amendment had affected this one section, and then there was something else in another section. And I think, but I think the idea of trying to do a plain English approach is a very important one. I think there is also opportunity to try to figure out how to use images and mapping. Nowadays we have GIS to try to show that more clearly. So there are ways forward to try to deal with it, but it does require a commitment. Obviously, whenever one is in a specific area, lawyers particularly, we tend to sort of hyper specialize and cross-reference and careful of using an acronym or whatever. And I think it requires a sort of a cultural change to remember who is the ultimate audience here, and that audience should be the public and should be somebody who, earlier there was this discussion about ANC commissioners, and ANC commissioners are volunteers. They have a life, they have a job, and now all of a sudden they have to deal with all these issues. As you very well know, it can be exhausting. And I think trying to make it so that it's accessible to people, is the person walking by on the street, is important. I know that we have felt, since we've taken on this public advocacy position, OAG has been really trying to work to try to promote zoning literacy by doing outreach, by trying to help for groups who are interested or have a specific question, trying to provide some reference points and education on that. We've thought about trying to see if we can't do sort of PowerPoints or FAQs, frequently asked questions, sort of sheet on basic aspects of zoning to sort of help everybody who, you see a notice going up in your neighborhood. What does this mean? Where do you go? And I think it's something we've been grappling with, trying to figure out how we can be helpful. And I'll just throw this out to all of you that we would love if anybody here has thoughts or suggestions as to what areas, what subjects we can sort of help elucidate, and or sort of formats, whether it's a PowerPoint or a sheet of paper or whatever. I think that would be helpful. But I think that goes back to that process. I think a lot of it can be done from the grassroots. But yeah, it does take a commitment.
What about that? A very simple suggestion to, in the zoning notices, supplement the lot and square with the actual address. I mean, that's a real kind of quick fix that it'll engage people. I mean, are you in a position to push for that?
Well, I'll give a cautionary tale because when I was at DCRA, the building permits, which is an argument in favor of that, the building permits are listed by address and not by lot and square, which is fine except when you get to a corner lot. And so in one particular case, it was a very expensive situation for the city where a permit was approved on a lot that was subject to an easement because there was a massive DC water sewer underneath. And so we had to condemn the property because unfortunately they changed the address and therefore nobody caught the fact that there was this easement because it was listed under street X as opposed to street Y. So there is a benefit, in other words, to using the lot and square, but it is exactly that issue of it's inside baseball. And it would make a lot of sense to have an address associated with
You
it.
can
Exactly.
do both. You just do both. And yeah.
Can I ask the audience a question? Who knows their address? Okay, who knows their lot and square? Okay, so this is an unusual
informed
audience that knows your lot and square. But I will say that in the last comp plan amendment, there were property owners who Office of Planning had submitted map amendments for their property. The property owners had no idea. They were not consulted, they were not informed, and in this case, these were properties owned by churches. They couldn't see their address listed, of course, even if they knew to look at, the map amendments. And I think the reason why everything is so hard to understand is very intentional. The lawyers from Holland and Knight understand it very well. It was set up to serve those interests. Let's be very clear. It was not set up to serve Ivy City residents and Berry Farm residents. And I have to say one other thing that makes it, to me, very clear that this is the intention. When the city was pushing the map amendment for Berry Farm, the Office of Planning worked with the developer to manufacture this appearance of community support by bringing out residents to this hearing who had not been really fully informed about what this map amendment, what the implications of it were. So nobody told them, for instance, that once you have this map amendment, there's not going to be any more PUDs. There's not going to be any more hearings. You're not going to have a space to negotiate community benefits. And it was intentional. It was really using people to create the appearance of community support without fully informing people. So I think that it's very intentional that they've kept the system so difficult to understand.
This is an equal opportunity meeting, so let's move on to the council. When council members are confronted with complaints about the zoning commission or the BZA processes or decisions, often they say they have nothing to do with zoning, but that's not really true. The council has legal authority to influence a lot of zoning actions. First, they confirm or reject the mayoral nominees to the zoning commission and the BZA. Second, they have oversight of both bodies and approve their budgets. Third, they approve the comprehensive plan, which is the only guidance those bodies can't ignore. In a more in the more recent amending of the comp plan, the council shocked many of us by seeming to abdicate their role by giving the zoning commission great latitude to make decisions that would be appeal-proof. There was little guidance on zoning of appropriate heights and densities across the city, and thus the zoning commission can arguably do anything it wants with no legal recourse to hold them accountable to make responsible decisions based on comp plan guidance, because there isn't much guidance. A lot of the vague language in the comp plan policies were rejected by the council, but the council didn't apply the same vagueness standard to how the ZC makes decisions about height and densities, which is usually what the public cares about. Laura, why did the council care about vagueness in the policies but not in the development standards? And can the public, this is basically the question you asked me, I'm turning it back to you, can the public persuade the council to really guide the zoning commission as our governance structure intends?
Yeah, I think we can, and there was a lot of pressure brought to bear on the council on those provisions at the time of the 2021 amendments, and we were not successful at that time, but there was a level of awareness. And as I look at the number of people out tonight who came here to talk about zoning, I think we're reaching this critical mass where you can kind of get some real activity. And I know there are several ad hoc groups, and I see some representatives here from one of them who are, also starting to work on raising public awareness. So it's time, and I think now is the time, because the kind of the city's fallback position has sort of collapsed under the weight of COVID. You can't say, well, we got to do it this way. We're recession proof, so we'll build and build and build, and it's not going to hurt anything. And you also can't say, well, we are the city of the knowledge economy, and because that same knowledge economy also proved to be a very mobile economy. So now that the old models are no longer working, this seems to be a very ideal and opportune time to say, okay, what about some policies in the comp plan that have some staying power?
I just want to, alert us to the threat of this upcoming rewrite of the comp plan. I mean, the council made it pretty clear that they want to drastically shorten the plan, which means less specificity, right? It's going to be more vague, probably, and serve the developers' interests more. I found out today that the neighborhood planning division of OP is not leading the comp plan this time, that it's the citywide planners. I'm not exactly sure what the implication of that will be, but evidently they internally considered it the last amendment cycle to be a failure. Okay, I don't know what exactly about it was a failure, because I think it was probably more engagement. You tell me, because you were involved in so many comp plans, but was there more engagement in this last comp plan than you saw over the last few decades?
There was much more community involvement, in part because you could go online and put in your comments there, even though they once again got ignored. But it was the changing demographics of the city that fostered more activity. If you bring in a whole bunch of college-educated people and who are young and ride their bicycles around and don't have a lot of children to kind of keep them up at night at PTA meetings, yes, they're going to get involved in something. And also, they have this great organizing vehicle in the Greater Washington. So there was a means there to kind of get people go out and going. So we had a whole lot of participation from that wing, but also I'd say, on the side of the Angels, and the disenfranchised, etc., there was much more activity because over time, we've gotten more sophisticated and we've built up our networks. And of course, you have been very instrumental in building up a counter network. So there was a lot of citizen involvement, and that was good. What was not good was the fact that the council dropped the ball on some major issues. Also, the racial equity piece got a lot of publicity. People knew it was out there, and that galvanized folk. But the council, they're still stuck on like, we got to bring in. If we don't accommodate downtown development, the city will fall apart. They really believe that.
I actually would say that in 2006, there was a lot of organized information sharing, and by the Office of Planning. The 2006 comp plan was the first one that I was actually involved with, and I was amazed how, not really knowing what the prior experience had been, but there were probably 2 or 3 at least ward meetings, no sticky notes involved. They were actually substantive meetings where there were PowerPoints and there were information was shared about, we're going to talk about the housing element or we're going to talk about the education element, and this is what it contains now. This is how we use it. This is why these policies matter. And then we broke into smaller groups to discuss different parts of the comp plan. And this is how the ward priorities got developed from these types of meetings that were being held across the city. The amendment cycles that I'm familiar with, there were maybe, I don't know, 2 dozen amendments to the comp plan. They were not particularly, well, they probably were very impactful because probably only the land use part was really paying any attention. But the amendment cycle wasn't used to rewrite the comp plan as we experienced in this most recent amendment cycle. So while there was a lot of involvement this time around, I would say it was a different quality of involvement. People weren't being told and informed why this was important, and specifically this element does this area element does that. It was very top down with the Office of Planning telling us, this is what we're going to change, and we don't really care a whole lot what you think, but you can write us and we'll, publish your comments or whatever, but you're really not going to have much influence, and indeed we didn't. We did have some influence with the council, but not enough. So I think going into this rewrite, we really have to be very aggressive and active in making sure that the council understands what our expectations are for this process, as well as the Office of Planning. Office of Planning is going to want to do exactly what they did with the last amendment cycle, even though they may not think they were particularly successful. The degree of what they wanted to change was astounding. So I think from most of our perspectives, we would think they were pretty darn successful, but they were attempting so much, and surely they're going to come around again to try to get what they didn't get, and also to expand their aspirations. So we need to sort of wrap this up, because I do want to hear, we all want to hear what some of the audience comments are, but let me frame it with one more question to our panel. When you're discussing policy matters, including fairness and inclusion in planning and zoning, it often comes down to politics if you really want to see change. The mayor and the council both have significant roles. The public has experience with some activities, like our sticky note meetings, and they have views on zoning meetings if they've ever participated. But are these folks enough to force change? Does the public sufficiently realize what changes could happen and how they can influence the likelihood of change? What recommendations would each of you have? Max, we can start with you if you'd like to jump in.
Sure. Yeah, I think one can make a change. One has to believe that one can make a change. I think it's easy and understandable to become resigned, to be worn down by the process. But I think it's crucial for everyone to express themselves to the extent that they can. I think the comp plan, sort of piggybacking what you were just talking about, Nancy, the comp plan amendment cycle that's going to be coming up is going to be crucial for everyone as much as possible to get involved early and to get others involved. But I think change is possible. I will say, for example, the WMATA text amendment that you cited earlier, that came out. We were all sort of surprised, but I think there was Power and the Committee of 100 and OAG and others in the community all weighed in. We managed to weigh in quickly before the set-down hearing. And although the commission in that case indicated they didn't have to listen to those public comments, I think they did hear some of those the questions. So I think that was the role, right? Was to sort of pre-vet and sort of raise concerns. And I think that worked there. I think there was another case, 2301. So that's the zoning commission case number. It was a text amendment that amended. It was for campus plans, related to campus plans, and I believe the Committee of 100 was the only one to submit comments, but it was a similar situation where it was a text amendment that wasn't clear who is going to be affected, and the Committee of 100 raised that issue, and one of the zoning commission members asked that and clarified with OP as to which, in this case, was Howard University, that was the sort of the catalyst for this particular text amendment, and indicated what other universities would be impacted by the text amendment. So I raise those as, we have to believe we can make a change. But it does take organizing. It takes time. It takes commitment. It takes, that drive to make sure to carry through and present the evidence of why your view matters.
Yeah, I think that it's possible, to make some changes this time. And, as you say, it all starts within, yourself. So I think there are several external galvanizing factors this time. And one is the RFK Stadium. And whether or not that goes into the plan or not, it probably will at some point. But it is a major sort of planning issue, which starts getting people around the city thinking about things. And you can move them from what do we do with the stadium and all the land around it, and whose ox gets gored, and who benefits. And you can get them from there to the comprehensive plan. Those things tend to work together. How much money are we going to throw into rebuilding downtown again? And what are going to be the ancillary benefits? So I think those two issues. In addition, I believe the comeback plan had a lot of promises about Black home ownership and some other kind of equity issues. And I think that got enough publicity to breed some expectations. So I think that that's a good kind of hook to get people into the plan. So those are some factors I think can gin up interest, even though they're not right in the plan itself.
Before we hear from Parisa, I just want to invite the, excuse me, the audience, if you'd like to make a comment about how we can see some positive change in planning and zoning, please come to the microphone. I'm going to ask everybody to limit your comment to 1 minute or less. But we're very interested in hearing what you have to say. Parisa, go ahead.
I'll just say really quickly that, I wouldn't be an organizer if I didn't think that we could make change, of course. But in terms of talking about the comp plan, my lesson learned is to really focus more on the land use maps. The biggest victory that we had related to the comp plan was the Cromell School. And I'll give you a little secret, because while we worked on this for over 20 years, I think it was our defeat of the mayor's attempt to change the land use map to add housing to the site that really won it for us. I mean, that coupled with front page coverage on the Post and all of the public awareness. But had she gotten that map changed, she probably would have continued down the road of trying to build those condos that she had already approved the developer. So, I think the land use maps it really should be our main focus this time around.
Laura, do you have anything you wanted to add?
No, I'd really like to hear from the people lining up at the mic.
All right. Carol.
Thank you. I actually have 3 items that I want to sort of put forward. One relates to the future land use map, and I feel like there's, I'm sorry, is that better? Yeah. Okay. One relates to the future land use map, which I think the zoning commission interprets to mean that is what should happen, not that it is up to that point that can happen. It's possible but not required, and that they just rubber stamp. And I just think if there's some way to do, like, I don't know whether it's a text amendment or a policy or something that just has them recognizing that they don't have to go to the total maximum density that's on the future land use map. I interpret it that way. I don't know if that's right. Maybe that's not even right. Maybe that is a requirement. The second thing is that for affordable housing, there's nobody who doesn't support affordable housing as far as I know. But the way it's being used to ram through densities and heights inappropriate in their setting for a de minimis amount of affordable housing just by using those words, I think is kind of a travesty. And I wish we could think of some way to separate those two issues. And the third thing is, I heard a rumor that the zoning commission composition could be legislatively changed by the council. So at some point, I would like to find out if that's true.
I will say that the first comment you had, there is language in the framework element that the densities approved on the FLUM do not automatically mean that the zoning commission should approve the highest density in that zone category or in that density category. The language is there. It's whether it's being implemented.
Hi, Alan Gambrell, an Adams Morgan resident, and I've been before the BZA and Zoning Commission a handful of times. And I wanted to compliment your white paper in raising the issue of the undemocratic nature of the decision-making process, but I want to take it one step further. And I've searched for the word, and it's integrity. And I'm talking about the integrity of individuals, specifically on the Board of Zoning Adjustment, who in testimony I've been involved in cases I've been involved in, will hear the regulations, the facts, and simply disregard them. And that's really has to stop. But as far as a tangible a recommendation, I would like to suggest that one thing I've heard from the zoning administrator a number of times before the BZA is the term, "It's been my long-standing practice." He says that. He provides no evidence of what it means. He does not document it. Nobody on the BZA asks what it means. So if there's a way the public can make that particular thing stop, that would go a long way.
Thank you.
Hi, I'm Debbie Chalfie with Art Deco Society of Washington. And one thing that hasn't come up tonight is historic preservation. and OP's influence on the Historic Preservation Review Board. I've seen a number of instances where the Historic Preservation Review Board is either being unduly influenced or unduly deferential to planning and to developers. And I think it's of concern to many of us who think that, historic preservation, is grounded in law. It's something that the review board is supposed to be supervising pretty independently of the rest of the process. And there just seems to be a lot of sort of oozing into that process as well. For example, the new Connecticut Avenue development guidelines and the impact that could have on the Cleveland Park Historic District. So I just want to raise it as another issue, another concern, another piece of the planning and zoning process that has an impact beyond just what's been talked about so far. Thanks.
There's been a traditional line between historic preservation and zoning, and they do not cross over. And each of those bodies have been very careful about that. But as the last speaker just said, the Connecticut Avenue development guidelines, which are in reaction to what the council asked the Office of Planning to do before there would be upzoning on Connecticut Avenue. The Office of Planning is taking that opportunity to go to the Historic Preservation Review Board and saying, well, there are 2 historic districts on Connecticut Avenue here, so don't you want to adopt and approve these development guidelines? Well, as the speaker, she was more probably politic than I will be. Absolutely no. One is development guidelines and furtherance of zoning, and the Historic Preservation Review Board's mission is entirely different.
Hi. I think zoning is hard. It's not something that I grew up with, unlike Max Tondro, with listening to my dad talk about zoning regulations. And I would dare say almost nobody else here had that advantage. So I think, first of all, more public education about the rules. What are the rules and what is the process is important. Also, I think the zoning commissioners themselves need to go back to school. I have watched situations where they seem absolutely clueless, totally oblivious to what the rules are. And it's my understanding that they have little meetings sometimes with the Office of Planning to coach them about, they're sort of like little continuing legal education type of sessions. So they're relying on OP staff, not only with respect to the general rules that they're getting coached on, but also with respect to specific development. I mean, the word integrity was used. I think that's certainly part of it. If the zoning commissioners don't know the rules, then they ought to hire some people with independent knowledge to help them do that.
Thank you, Sandra. We're going to limit the questioning to those people who are currently in line. So Faith, you're not currently in line. Don't sneak in there so that we can, go ahead. And please try to keep your comments to a minute or less. So we can
I hope so.
Everybody.
I don't have that much to say. I read the paper on the train, and I want to compliment whoever did it. I thought it caught almost everything that I could think about, and did it in a way that was clear and to my mind, correct. I'm on an ANC. I am curious to understand why it is the role of the ANC was not covered. The ANCs actually are a potential voice from sort of the other side and from the citizenry. And the problem with the ANCs, they're extraordinarily handicapped. And not only do they not have information or analysis, any source of analysis, we can get it in part from the new office in the in the OAGs, but we also are there is a small area plans. There were small area plans that were legislated to be not only done but then incorporated into the comprehensive plan, and they're completely ignored. And that's extremely serious problem, because that's the moment at which you have, in fact, an analysis which is bottom up and rich. And if it is ignored by all parties, we're sort of back to square one. And not only that, you will then ignore any of the protective dictates that might be in the comprehensive plan.
Thank you.
Hi, my name is Renee Bowser. I'm a Ward 4 resident, but I'm speaking this evening as the new attorney for plaintiffs who embarked on a historic lawsuit suing the District of Columbia because they did not follow the regulations as they were at the time the 2021 amendments were passed. They did not do the type of assessment when they changed particular provisions, and they didn't do an environmental impact assessment. The environmental impact assessment was 5 pages and didn't mention any of the upflooding. So we have the case that's called David Belt versus the District of Columbia, and right now we're reaching out for expert witness to work with us as we try to complete discovery. Just to step back a second, the case has been going on since 2021, but I've just been involved since July 9th, and we're trying to make up ground because the prior attorney was very ill and was unable to complete her duties. And so if anyone wants to learn more about the lawsuit, it's in the Superior Court with Judge Maurice Ross. And we're looking for an expert witness to show the importance of the changes and what the District of Columbia did not do in looking at before they made the changes, particularly the upflumming. There's nothing that discusses that, and we haven't gotten any information on that from them. The only other thing I want to say very quickly is we talked about bringing these zoning issues closer to the people, and using address and in addition to lot and whatever. But we need to put these things. We have to pressure the district to put these things on DCTV. People watch DCTV, and there'll be times where, at times, as when I was an ANC commissioner testifying before council, they'll see it when it happens, and they'll see it 6 months later, they'll replay it. If you put the advertisements on DCTV, because the comprehensive plan says that everybody is supposed to be, the whole community is supposed to be involved. But if you don't know about it, you can't be involved.
Thank you.
That's all.
Thank you, Renee.
I'm proud to be a plaintiff in that lawsuit.
Hi, my name is Aiden Jacoby. I appreciate the talk of racial equity that was here today. I think a lot of people want to move to DC. There are good jobs here and the market's growing. More demand and the same supply of housing means prices go up for everyone. That's not good for renters who are majority people of color. So we build more housing. But because some areas, the richer and wider areas, have the time to show out and oppose new housing in their neighborhoods, they fall behind affordable housing requirements, they fall behind market rate housing goals, and then all that housing development is concentrated in the poorer, blacker neighborhoods. So it's not development, which is inevitable because people are moving here, that causes displacement. It's the increased political power of certain neighborhoods over others. And having it more difficult to build housing in those neighborhoods is just going to make the problem worse. I would love to see organizations in the district, but organizations like Empower DC, go to Ward 3, go to neighborhoods like Chevy Chase and neighborhoods that are similar to Chevy Chase, and tell them, hey, you need to build housing so it doesn't all have to go in our backyard. And I think today what we've seen here is there's not really the will to do that, and it's just going to make displacement and racial equity in the city worse and raise rents for everyone because less housing will be built.
Thank you. Last commentator. Yeah.
My name's Jerry Johnson. I'm a former ANC commissioner in the U Street corridor. My question is for Max.
We were hoping not to have questions and just
Oh,
comments,
just comments.
But why don't you ask it and then you
I'm
can
going
you
to.
can talk to him after.
Yes.
So go ahead and let
so
us know what your question is.
We haven't discussed the constitutionality issues with respect to equity, especially as they pertain to land use decisions. I mean, I think most people here know that a zoning map amendment has to meet Fifth Amendment requirements with respect to due process, and it also has to meet 14th Amendment requirements with respect to the Equal Protection Clause, although we rely on the Fifth Amendment for that here in the district. So my question is, with respect to the equity goals of the district, how do you meet or how do you pursue those goals and at the same time meet the constitutionality requirements? Because those goals are often discriminatory in nature and, of course, are likely to be subjected to constitutional challenges. So, easy question to answer.
Max,
I look forward.
Can you answer that in a minute or less?
Sure, I'll try. There's always the classic lawyer's response, which is depends, or the devil's in the details. But I think that zoning has always been predicated on the idea of the police power to protect the public health, safety and welfare. And so there is already that was upheld almost 100 years ago by the Supreme Court as being constitutional. So I think it will depend on the details, the specifics of what it is that is being applied and how that is applied in the justification. So unfortunately, it is the devil's in the details.
Will you all please join me in thanking our panel for stimulating and informative. And before everyone adjourns to the narthex for some refreshments, I want to let everyone know that the culmination of our year-long centennial for the Committee of 100 is going to culminate with a gala on October 10th, right next door at the Martin Luther King Jr. Library at 6:30. You can get details about it. I think there are some out in the narthex, actually, but you can also check our website, which is committeeof100.net, for additional information. And we'd love to have all of you come and help us celebrate and plan for our next 100 years. So thank you all very much for coming.